1 year ago today, the United States Supreme Court surprised many by rejecting a radical fringe theory that would have overturned 200 years of precedent and upended American democracy. But guess what? Republicans are back in court trying to revive it. Welcome back to Democracy Docket. I'm Mark Elias.
And I'm Paige Moskowitz. Let's get started. In Moore v. Harper, the United States Supreme Court rejected North Carolina Republicans' attempt to validate the independent state legislature theory. Mark, remind us what this theory is about and why it's so dangerous to American democracy.
Yeah, so this is a fringe theory that it is almost crazy to say that we are still talking about, that it is alive and kicking. It would say that state legislatures and state legislatures alone can set the laws for how federal elections are conducted. So in its most extreme form, governors don't get to veto those laws. State agencies don't get to interpret those laws. And most importantly, what Republicans are really after is that state courts wouldn't be allowed to strike those laws down by applying their state's constitutions. So this creates a circumstance in which state legislatures can pass any law they want about how elections are conducted unless Congress has passed a contrary law, and there is nothing the governor or the state courts can do about it.
And what exactly happened in North Carolina that led them to the U.S. Supreme Court and led them to try to bring this theory to life?
Sure. So the last time this came up, the most serious effort, as you mentioned, Moore v. Harper, which was decided 1 year ago today. So happy birthday-ish for Moore v. Harper. But the North Carolina legislature enacted a extreme partisan gerrymander of their congressional maps. That was then challenged in state court. The state courts, including the state Supreme Court, struck it down under the North Carolina Constitution. The Republican legislature then brought that case to the U.S. Supreme Court and said that since the maps had been passed by the Republican-dominated legislature, that the state Supreme Court was powerless to apply its state constitution to it. And frankly, Paige, people thought that there was a real chance that the Supreme Court would adopt the independent state legislature theory as a doctrine. Democracy Docket has extraordinary coverage on this, and we're going to put a link in the show notes below to an entire, center of information that it's really important people stay up to date on, because this doctrine has come back about the independent state legislature theory. It would have upended the way in which we think about how laws are passed, and most importantly, how they are reviewed by courts, by essentially creating an exemption from normal judicial review for laws passed by state legislatures. So a really, really fringe theory, a really, really dangerous theory, a theory that made it all the way to the U.S. Supreme Court, got some votes on the U.S. Supreme Court, by the way, not a majority, but a theory that for anyone who thought it was over and dead and buried is back.
You said that the theory did get some support from Supreme Court justices last year. What did SCOTUS actually rule about the case?
Yeah, so in a 6-3 decision, the Supreme Court rejected the fringe independent state legislature theory and rejected the notion that state courts cannot interpret their own state laws or interpret their own or apply their own state constitutions. They left a little bit of wiggle for the outlier circumstance where a state court so violently deviates from the plain text of its own constitution or from its own precedent that it would violate the federal constitution. I think everyone saw that as, kind of the as a theoretical possibility, but not something that we would see happen or something that is at all likely, since state courts don't tend to deviate from their state constitutions. That's why they're there. They're there to apply their state constitutions. But it was rejected. There was a dissent from the usual suspects, but it was pretty soundly rejected. And you would have thought that the Republicans would have taken this to heart. But lo and behold, every time, Paige, we think maybe Republicans have learned a lesson and should embrace democracy rather than subvert it, we are proven wrong.
I think it's helpful to give people a bit of understanding of things that have happened that may seem very normal in the course of the legislative process, but things that have happened over the past year that maybe wouldn't have been possible if the Supreme Court had ruled the other way in Moore v. Harper. So, Mark, can you give us some sort of breakdown about the kind of routine election efforts that have happened over the past year that is actually kind of miraculous that they did happen because Moore v. Harper was ruled in this way?
Yeah. So, I mean, to say that this would have been an earthquake of a judicial decision if it had come out the other way, or if any of the new challenges succeeded, is in some ways an understatement. The Kentucky Supreme Court upheld the congressional map. New York's highest court, the Court of Appeals, struck down its congressional map. A Florida judge struck down its state's congressional map in a case that's, by the way, now in the state Supreme Court. Governors in Arizona, California, Virginia, Wisconsin vetoed election-related bills. The Montana Supreme Court upheld a lower court decision striking down some of their state's election laws. An Ohio group or a series of groups have gathered signatures to reform the redistricting process. All of these things, all of them, are things that proponents of the fringe independent state legislature theory claimed are unconstitutional. And I really encourage everyone to take advantage of the resources of Democracy Docket, because no news outlet has covered ISL like Democracy Docket has. It has resources that are unparalleled really by anyone else. And Democracy Docket is making a special offer right now for, if you sign up on the link below, you will not only get access to its free daily and weekly newsletters, but for the next 2 weeks, you will get access to its premium content. And, we have there's going to be a lot of important things happening in the next 2 weeks. The link to that is in the show notes below.
You mentioned the Montana Supreme Court decision, and that's actually really big because it's one of the ways Republicans are trying to bring back the independent state legislature theory. It's Republicans both in Montana and in Pennsylvania, but I want to start in Pennsylvania because it is the earlier case. So what is happening in the Commonwealth?
Yeah, this is a good example of just how fringe and extreme this theory is. And also, Paige, kind of how elastic and undefined it is, right? Because, I described Moore v. Harper as about limiting the ability of the state courts to apply their state constitutions. This is actually challenging. I laugh to say this because it's so preposterous. This is actually challenging an executive order that President Biden issued to agencies to encourage voter registration, and a policy that the governor of the state put in place to encourage automatic voter registration. I mean, neither of these are particularly extraordinary actions. I mean, the president of the United States issuing an executive order saying, hey, agencies, make sure you're helping people register to vote, and the governor of a state encouraging automatic voter registration is not exactly out of bounds, right? That's pretty standard stuff that you see governors and presidents do. But it's being challenged using this fringe theory, saying that because the president of the United States isn't the Pennsylvania legislature. And by the way, Paige, kudos and shout out for calling it a Commonwealth. This way we won't get those comments. So, Paige showing she knows Pennsylvania, like Virginia, Commonwealth. But that their position is that since the legislature didn't do this, the president of the United States doesn't get to tell agencies and departments to help people register. The governor of the state doesn't get to put out a policy. I mean, it's preposterous, but it shows, like I said, how broad it is. Not just that they don't want the state courts, they don't want governors, they don't want presidents doing anything to promote voting. And so it is a very, very dangerous theory. And the Republicans in Pennsylvania, as usual, showing that they can take a dangerous theory and show just how preposterous its results would be.
What is the status of Pennsylvania Republicans' case now? How far are they in advancing the ISL theory?
So it's not going really well for them, which is not a surprise. Republicans tend to file a lot of lawsuits and they tend to lose a lot of lawsuits. As a subgenre, Republicans in Pennsylvania tend to file a lot of lawsuits and lose even more on average than Republicans around the rest of the country. Paige, there are more lawsuits right now pending in Pennsylvania than in any other state. And that information is available exclusively by going to the Democracy Docket website, where they track all of the voting rights litigation around the country. But the case has not gone well. They have it was dismissed at the trial court level, not surprisingly. They have appealed it to the Third Circuit, where they're going to lose. But they've also simultaneously asked the Supreme Court to take the case directly in a very not widely used, rare maneuver called cert before judgment. I think it's very unlikely. That overstates its probability. I think it's very unlikely that the U.S. Supreme Court is going to take this case. I think this is going to dead end with a denial of cert at the Supreme Court, and the Third Circuit's going to rule against them. So as ISL cases go, this is very, very fringy, and I don't think it's going anywhere. But it shows you that this is a very amorphous doctrine, as I said, and it really lends itself to shapeshift, which makes it dangerous, and a reason why Democracy Docket covers it so closely.
You called Pennsylvania Republicans' lawsuit fringy. They're not following the normal court process. They're doing a lot of weird things, but they are receiving support from Republicans in other states in this effort.
Yeah, Paige. I mean, it's hard to believe this, but 9 Republican secretaries of state from other states have filed an amicus brief supporting this claim. And perhaps less surprisingly, 11 Republican House members have filed an amicus brief supporting this claim in the Supreme Court. But I mean, the secretaries of state who are supporting this claim are actually supporting a claim that would divest themselves of power, right? The whole idea of the independent state legislature theory is that only the legislatures have power, right? So like this lawsuit says governors don't have power. Paige, guess who else wouldn't have power? Secretaries of state. I mean, this just shows that not only is MAGA a cult, it's a dumb cult. Like, they're not even smart cult members. I mean, why would you, if you are the Secretary of State of West Virginia or Arkansas, Louisiana, Mississippi, Montana, New Hampshire, Tennessee, or Wyoming? And by the way, if you're a citizen of any of those states, your tax dollars are being spent on briefs to the Supreme Court on this nonsense. But why, if you are the Secretary of State in one of those states, would you file a brief that says that in Pennsylvania, a state you're not in, that the governor and the president don't have power? You are literally undermining executive authority when you are part of the executive branch.
Maybe not surprising that one of the secretaries of states who signed on to this Pennsylvania brief is also trying to promote the ISL theory in their own state. Montana Secretary of State Christy Jacobson is appealing a decision from the Montana Supreme Court that struck down 4 voter suppression laws to the U.S. Supreme Court, again, claiming ISL.
Yeah, this is a case I take more seriously. I still think it's a very, very, very long shot, but it's a little bit more of a traditional ISL case. The state Supreme Court in Montana upheld a lower court decision striking down 4 voter suppression laws. These are very, very, bread and butter kind of voter suppression laws like you'd see around the country. In full disclosure, my law firm represented the plaintiffs in the case striking this down. The case went up to the state Supreme Court. The state Supreme Court, like I said, upheld the lower court decision to strike those down. And now the Secretary of State of Montana has sought an extension of time to appeal or seek cert in the U.S. Supreme Court, and indicates that the reason why they need more time is because they're going to, ask the Supreme Court to hear the case. So what they've asked for is essentially a routine kind of administrative extension, but they've asked for that extension because they intend to re-challenge Moore v. Harper pretty explicitly. And Democracy Docket exclusively reported that they were seeking this extension precisely because they want the Supreme Court to essentially cut back on, not necessarily overrule, but cut back on Moore v. Harper and come to a contrary conclusion.
It's interesting that they're asking the court to cut back on Moore v. Harper because literally this decision is a year old. And the Montana case is almost exactly the same as North Carolina, right? Like the legislatures passed some election-related act. It was struck down by the state Supreme Court for violating the state constitution. They're now asking the U.S. Supreme Court to overrule the state Supreme Court. Why bring almost an identical case a year later? asking for almost the same thing.
We need to take conservatives seriously. We try to use some amount of humor and mock the ridiculous lawsuits that they file. We point out the fact that their lawyers seem to constantly be getting disbarred, that Rudy Giuliani was a clown, that that a number of their lawyers have now been caught up and been indicted. But the fact is, Republicans bring these cases back to the Supreme Court and bring the same cases over and over because they know that if they do that, they may eventually get a different outcome. The fact is that Republicans lost the abortion case, Roe versus Wade. And then over the course of decades, not years, but over the course of decades, they kept bringing the case back up over and over again. And people would dismiss it and say, oh, that's just another effort by the religious conservatives or the right wing to just, play to their base. No, they were trying to poke holes in the fence. They were trying to find another way in, whether it was through a different doctrine or a different composition of the Supreme Court. And eventually they succeeded, and it was a catastrophe. It was a legal catastrophe for tens and hundreds of millions of Americans and for the credibility of the Supreme Court. So do I think that the Supreme Court is going to give them that opportunity 1 year after they dismissed Moore v. Harper to bring this case back and essentially have the Supreme Court reverse itself? No, I don't. But is it what they're trying to do? Yes. And they're trying to do it because it has worked for them. The Supreme Court has shown itself willing to overturn precedent to achieve the conservative legal agenda. And conservative groups know that. And so we cannot be complacent and not take seriously these cases like the one in Montana, like the one in Pennsylvania, because then they sneak up on us and we're left asking ourselves some June next year, a year, 2 years from now, some June, we're left saying, how did this case get this far? How did this happen? How did we wind up in a world in which this incredibly important democratic principle was overturned? So we need to fight these cases at every stage. And Democracy Docket exists to shine a light on what the Republican and conservative judicial movements and legal movements are doing. They are pressing and probing to find the weak spots in our democracy. They are pressing and probing every day to try to get a different answer because they didn't like the last answer. They are trying to get a different election results because they didn't like the last election results. And so I hope everyone takes advantage of all of the resources on Democracy Docket, becomes a free subscriber to the daily and weekly newsletters, reads the case pages, reads the source materials. You don't have to trust me or Paige for what we're telling you. You can read the opinions yourself. And for the next 2 weeks, takes advantage of the exclusive offer that Democracy Docket is making to allow you to get access to premium content, more analysis, more information about all of the critical cases that the Supreme Court and other courts are deciding that will set the stage for how our elections are conducted in 2024 and beyond. That's all we have for this edition of Democracy Docket. Thank you for joining us. We'll see you next time.